So this paradise lost is so philosophical in its own terms that you can make multiple interpretations out of it. I would also like you to share the reasoning for this particular title.
I was very much inspired by this particular term used in a particular judgment, wherein the constitutional validity of the insolvency code, the particular law which we're talking about which the book is, that was challenged in the Supreme Court. And the then Honorable Judge who wrote that judgment, Justice Nariman, he very beautifully put it that the defaulters' paradise in India is lost, and the Indian economy has rightfully gained its position, which indicates that India was, at least for the last maybe couple of decades, a paradise for those who wanted to default by nature. Take it for granted, take it easy, take the monies from the banks, don't give it back. So that defaulters' comfort zone, paradise. And I said, "Nahi, theek hai, there should be a book which should bring this out to the people. A book which is, yes, written by a lawyer. It's not a heavy legal commentary."
I think in this country, people just don't want to respect the Indian law, or they don't know what is the power of Indian law.
I think that in India, people do not respect the laws so much. That is changing. At least I believe that's changing over the last 8-10 years. But even having said that, there's a long way to go. Enforcement of the law, enforcement of contracts, enforcement of the law per se has somewhere been one of our, I would say, weaker points in the initial 50-60 years of
Is
our...
it because of colonization also?
I would not directly say that it is because of that, but I would definitely say that the laws that we have, at least a large part of our procedural law, which is now undergoing change, the criminal laws have changed, the new laws have come into place, which is more modern in nature. Contract Act, 1872. Now, or for that matter, any act of the 1800s, the 1900s, early 1900s, where they brought in to really govern a larger nation like India, or where it brought in by a particular company, the East India Company, to ensure that they are in power, one step beyond governing people, punish people where they're wrong, so on and so forth. It would not be fully right to say that it is just because these are old laws, enforcement is weak. There have been certain loopholes in the overall enforcement process over a period of time. Frequency of cases, shortage of infrastructure in the judiciary. We talk about scandals which involve lakhs and lakhs of crores.
Money laundering, basically.
Money laundering, lakhs of crores where there are politicians who've been involved and so on and so forth. How many of them have really been jailed? How many of them have really put behind bars for a really long period of time? The process just goes on, the trial goes on, the person is sitting outside an anticipatory bail. So generally there has been a perception, but now, at least from the commercial laws perspective, things are changing. Most of the laws that were around, or some of them are still around, they didn't have specific timelines, time periods to be where the process has to be completed. The punishments were not so stringent. The enforcement of those contracts was not taken up so seriously. We have a lot more technology to use. As they say, the justice part of it has to reach the last mile. It's not anywhere close there yet. But today you have enabling facilities, like you have, for example, video conferencing facilities. Today a person from a relatively remote place can attend an online hearing in one of the courts. If you have the infrastructure, it's only then you can really go behind people who are defaulting in the laws. But a lot of that needs to further improve to ensure that there's actually the rule of law in this country is respected by the citizen.
But now with online portals, banks operating online, RTGS, UPI, multiple things coming in form of online payments, has this increased the regulation more?
See, when you look at demonetization, coupled with post-COVID or during around that time, the strengthening of our, as they call it, the JAM Trinity, which is basically where you have bank accounts for every single person. They've been, encouraged to open bank accounts. The Aadhaar card concept, which is one single identity concept, and the revolution on terms of the 4G, 5G technology. So these put together, yes, definitely UPI payments, online payments have gone up significantly. As they call it, the parallel economy has come down to a large extent. And today you go right down to the very small towns, they're accepting UPI payments. So the usage of cash economy, use of in the economy has definitely come down. But to say that that has reduced money laundering per se, to some extent, yes, but not the only reason. But definitely, this has been I mean, it's nothing short of a game changer either, because you are obviously cutting down the movement of cash, which means that generally the flow of cash into the economy, where if there is one sector of people who are accumulating it, it also goes down. So this is a law which was brought in by 2016 by the present government. One has to go a little bit in the, I would say, previous 10 to 15 years of history to understand why you needed a law like this. If you would have asked me in one line, so why did we need a law like this? It was required for a cleaning up of the banking system. When I say cleaning up of the banking system, they were basically banks that were not recording loans which have already gone bad as bad loans, as non-performing assets, and a lot of it was being put under the carpet for certain reasons. The simple reason was the bank's balance sheet also, as on 31st March, had to look healthy, and the company which is the borrower, which has to give hundreds of crores to the bank, doesn't want to also be seen as a defaulter. So if I can say, this was some kind of a nexus also to some extent at that point in time. In this phase of 2004-5 until 2009-10, there was significant amount of heavy duty borrowings, indiscriminate lending by banks and indiscriminate borrowing by businesses. As a startup, if you were to go to a bank and ask for a reasonable loan of 25 to 50 lakhs, I think the bank would today ask you a lot of questions. They would ask you to present a business plan as detailed as possible. They'll do due diligence and all of that. This was something that was missing in the loans given in this period of 2004 to 2008-9. When, with the crisis put together, along with these loans going bad, indiscriminate lending, scams, policy paralysis, where there were no clear decisions being taken, a lot of projects, infrastructure projects were stuck midway, constructions were not happening, highway projects were stuck. So from 2009-10, these loans started showing distress. Either were struggling to repay the interest or to honor their interest commitments, and by 11, 12, 13, they had started turning into non-performing assets. The concern of the banks was, we're just coming out of an economic crisis. Let's not further expose this, which was actually, the amount was somewhere about 6 to 7 lakh crores. Let's not expose these further, that these loans have all gone bad. Unfortunately, there was something called, possibly you can call it evergreening of loans, window dressing of loans, wherein these bad loans, just to ensure they don't reflect as defaulted loans on the account of the banks, the bank would further sanction a small amount to the business and say, I will just, it's more of paperwork. I will sanction you a certain amount and I will take it back as though you have serviced me that interest. So the amount given was technically by the bank to itself servicing of interest, but then the books of both the parties were kind of clean on paper. Internally, they both knew they were in a mess. So this was continuing. This went on till, I would say, 14, 15, 16. What happened was the non-performing assets, it ballooned up to almost 10 lakh crores plus kind of a figure. And there were a lot of these companies which eventually ran through the insolvency and bankruptcy process, IBC process, SR Steel, the JP Jet Airways, Ruchi Soya, quite a few of the bigger names were there, Bhushan Steel. If a tough law was not brought into place to have a time-bound resolution system, they would have continued this whole, evergreening. How long would you do it? The economy was already, we had gone to a fragile 5 status in 2015-16. From there, we are today in the top 5. We are the 5th largest economy in the world. This law initially said whatever it is, one way or the other, in simple words, there should be result in 270 days, which later became 330 days, by which you should either have a resolution, which means some revival of the company, or liquidate the assets, as in sell the assets, whatever comes, pay to the secured creditor. There is a certain mechanism laid down. How do you pay the money to the people and all of that. At least from 2016-17 to 2019-20, a lot of cleanup happened. these companies were run into the insolvency process. Ease of exit was being introduced through this law.
Ease of exit.
Exit.
For,
Ease of doing business
for
is one
whom
thing.
exactly here?
Ease of exit for a business which is not anymore viable. So to answer again, your question is, was there a provision of exit earlier? There were some schemes brought in, like there was something called the BIFR that was brought in, Board of Industrial Financial Reconstruction of Companies. Not very effective. In these last 3-4 years, we have seen the Tata's take over the Bhushan Steel. We have seen the ArcelorMittal and the Nippon Group together take up the SR Steel. We have seen Ruchi Soya being taken up by the Patanjali Group. We have also seen something called a Kalrock Consortium taking over the Jet Airways. So third party acquirers are buying companies which are in a distressed position, and they are then whatever, they are revamping it, clearing up whatever maximum dues that what that company demands today, or whatever the company's values is there today, and they're trying to revive these companies, so that's going to have a multiplier effect on the business, on the employment that these companies generate. The examples that I mentioned, these were all through the IBC mechanism, through a legal mechanism in the court which is called the National Company Law Tribunal. So they acquired these companies through these processes. Judgment also to say that even if an acquisition of a company happens below the liquidation value, it is not per se illegal. But the general norm is that most of the companies get acquired at a liquidation value plus something more. But the unfortunate part of this whole thing is there is a significant haircut, but a significant amount of money that is lost out or which is not recovered by the creditors. Some companies still have a reasonably decent liquidation value compared to the total claims sought for. And recoveries are happening. There is always a debate that is this law for recovery or is it for revival? And the courts have time and again said, don't look at this law only as a recovery of your money law to the bankers, to the financial institutions. It's a law for revival of companies.
Is this something which only favors people who are business professional, or it is something to do with the common crowd?
It actually affects everyone. It can be both beneficial. It can be beneficial if you are a potential acquirer. It is also sometimes, if I can use the word, misused by some of the businesses which consciously ensure that they run the insolvency process. They go into bankruptcy, insolvency, or whatever it is. Through some third party company, they acquire their own company at a very nominal value by giving something called what you call a heavy duty haircut to all the other stakeholders. Now, when I say stakeholders comes in your question, who are these stakeholders? Financial institutions, they are part of the decision making process because they are something called the committee of creditors. Workmen and employees usually workmen gets up to 24 months prior to the date where the insolvency has started. They get their dues. Their dues are supposed to be provided as per the law itself. Employees are supposed to get 12 months of their past dues. So workmen and employees are financially, yes, reasonably protected, but there's always a sort of uncertainty hanging on them whether the company will continue or it will go into liquidation where the assets will be sold, whether the promoter who is generally fighting to get the company back will come back, or should they listen to this insolvency professional who is a court appointed officer governed by the financial institutions. The sector which I feel gets significantly hit, the people who supply goods and services, they are called the trade creditors or the operational creditors in the terms of IBC. They come right at the end of the supposed waterfall mechanism. Supreme Court has its perspective to say that no, this law was for financial creditors, for financial institutions, and there are certain reasons why they should be given a preference and a priority because they are the ones who are the lifeline or the backbone of the financial listing of the company. But if they are the backbone, then I would say the operational creditors are the lifeline or vice versa. Like home buyers, for example. Home buyers were in a pretty gray area situation earlier. But as the law evolved from time to time, JP Infra and then other projects and Amrapali and all of that, today the home buyers have a say in the insolvency process. They form a part of the decision-making body. It's not so easy to just walk over home buyers under the IBC. So while the financial creditors, the bankers are taking decisions, these home buyers who have also invested in the project also have a say in the resolution mechanism and the resolution process. So, similarly, I believe that the operational creditors should have some say or some protection. So, it is important that when you sign a contract as a signatory, irrespective of what is your type of your entity, you should know the contents, you should know what the contract is about. At least the key clauses. Are the name of both the parties reflected properly? Is the intent why this contract is being entered into, is that reflected properly? What are the rights of both the parties? What are the obligations of both the parties? Why are we entering into a contract? So that we put everything in pen and paper. And then also, what are the in specific obligations, confidentiality clauses? All of that is important. How are you governed by confidentiality? How is the other party governed? Then, in terms of what happens if there is a default and what constitutes a default of the obligation of either party. So, anything which is against the spirit of the contract, that would be seen as a violation. So that is what you call that I have defaulted in my commitment. Now you have to take a decision as to what do you do to bring me back on track, for which we have something called a dispute resolution clause, or a clause wherein in case there is a dispute, there are various mechanisms. There is mediation, there is something called arbitration. You could go to court against me. You can stop me from doing business from a third party. All of that is there. Please read the contract. Please read the terms that you're signing in for. A lot of these contracts, which are otherwise 50 pages, 70 pages, 80 pages, the crux of that can be actually captured in 5 to 7 pages. It's just that we are following a certain style of drafting over the years where everything is extremely verbose, very detailed. Same thing is written 3 times or 2 times, or the same things are put in an extremely elaborate manner. Term sheet is nothing but a tabulated column where on the left side you will have one thing called name of the party, and the right side you will have the two names A and B. Next row, validity of the contract, validity will be mentioned. To the point issue and the exact terms. This whole thing is typically, from what I have seen in most of reasonably decent sized contracts running into tens of crores. The crux of a contract is what is captured in a term sheet. That comes in about 6 to 8 pages, 10 pages at max. I think as a policy, younger companies, the shorter they have, or the I would say brief agreements, documentation that they get into, brevity is key. I would say it's very important that when you are signing agreements, you should be very, very well aware of what you're signing. Is also something which I tell a lot of family businesses, small family businesses. What happens is you've taken a loan, 50 lakhs or 1 crore. You're expanding your business. You need additional 25 lakhs or 50 lakhs. The bankers tend to say, sir, you don't have any further collateral to give, any further property to give us personal guarantees. Personal guarantee means if anything goes wrong, the bankers, and with the present law like IBC, they can come behind your personal assets. They can auction it out there, and it can go towards a stage where you're declared as bankrupt. You as the businessman signing the personal guarantee, that's your personal choice. But by and large, more than 75% of Indian family run businesses have their family members, their parents, their spouse having signed the personal guarantee. So you're realizing that in the quest of trying to either expand or grow or get more credit from financial institutions, you are exposing your near and dear ones. And if, God forbid, something goes wrong financially, the business goes down, see, you should be prepared to let go of your collateral, your security, because that you've given to the bank. Bank also needs to secure itself for you to give you a loan. Your personal guarantee, fine, but not of that of members who have nothing to do with the business. See, where you cannot negotiate, you can't negotiate if it's a government tender, government contract, financial institution, public sector bank, to some extent even private sector banks. You can't. But at least where you can, with your business partners, with your vendors, with your employees. And now, for example, employees, how strong is your non-compete, non-solicitation clause, or a clause where they don't take away your intellectual property? how strong do people have that with their employees? Most of them don't even have it. People who are working with you, they leave you and go. They can just take away with you them your clients, your intellectual property, your ideas, your data. What would you do? So your employment letter that you sign with an employee have these basic things in place. Aspirational middle class, which is now kind of rising in India. So yes, we have to struggle a lot to possibly get a loan of you're talking about big amount. I'm talking about 10-15 lakhs also. Show me a loan on 15 lakhs. Is it that easy to get with a simple setup that one may have? Bare minimum, you need to have at least an apartment to mortgage that. See, there are a lot of these RBI mechanisms that have been brought in, tightening of norms, tightening of like for something called the Basel III norms that are being introduced, where banks have to have some more. If the exposure of a private sector bank is X or a public sector bank, 10 or 15% they have to keep as a reserve with them at any point in time. So these are mechanisms by which banks are also put under surveillance and under pressure not to lend left, right, and center to these so-called big industrialists and corporate houses. Hopefully, ensure we put a system in place. One, the mistakes should not be repeated. And secondly, we put a system from here going forward where chances of loopholes, chances of these kind of issues are, I would say, I would hope, next to impossible. There are Indian companies, Indian promoters who have, with respect to the Uttarakhand Uniform Civil Code that's come in recently, there are definitely a lot of positives in this code as well, wherein a lot of personal laws have been made unified, common, codified, so that there is no discrimination. The intent of the government seems like is to ensure that there is no illegitimate kind of Kerala story situation happening in these places, wherein under the garb of a live-in relationship, there should not be something which is a larger danger to security. But it is not fair to bracket all of that under one shell to say no, everything is going to be risky. The other way of looking at it is live-in relationships have been, in a way, I can say, legitimized by the government. So there's one whole argument that this is a progressive thought process, that at least we are giving it an official status. Children born out of live-in relationships will not be termed as illegitimate children anymore. They would be, that is what the UCC of Uttarakhand says. They will have the fair legal right as a heir to the parent and so on and so forth. There is definitely a sense of concern. I can say some places criticism, some places concern by the younger generation to say that no, this is kind of getting into our personal space, because when I get into a live-in relationship, I need to register within certain number of days with the local sub-registrar or whatever it is, authority. And even when there is a moving out of the relationship, they have to be notified as well. I would say, yes, we'll have to wait and watch whether this is being productive or counterproductive. Because see, even the authorities will then have to become that sensitive, that mature, that it should not become a reason for them to, if I may use the word, harass the younger generation. Because today you go and you say anything which is not making sense or logic to the today's, I would say, 18 to 25 or 20 to 25, or that age bracket generation, or maybe up to 27, 28, whatever be as they call it, the youth, you will immediately have Twitter trends starting. You will have a lot of outbursts out there in the social media. That's one thing. Also, if there is something, as of now, there is no challenge to the UCC yet of it being unconstitutional. But if there are going to be any developments where there is any factual incident happens where it is seen that the authority is misusing the power of governing or trying to the big brother attitude in a live-in relationship, I'm sure the courts will intervene. The courts will step in and say that's where a lot of times even a law is put into place. You cannot anticipate on day one everything that's going to come in the way of the law, good, bad, ugly. So I think that's why you should leave it to the honorable courts to interpret and see what should be the parameters, what should be the benchmarks, so on and so forth. Within a liberalized country, I would say India is working towards being a more user-friendly kind of a legal system. See, liberal, yes, the basis for the yes is there have been about 19 ministries under which about 43, 42 laws that come in. And under that, 180 plus sections under these 40 odd laws have been decriminalized, which means that the provision was if you don't do this, you would be put behind bars. That has been taken off. Only fine is there. Similarly, there have been a reduction in a number of compliances, legal compliances. Some say 30,000, some say 50,000, but whatever be the number, there has been a reduction in the number of legal compliances. More than about 1,200, 1,300 old archaic laws, they have been knocked off, repealed. They did not make any more sense, so they have been repealed. So there are measures being taken in the judicial side as well. Now, whether you call it as liberalization, yes, you can call it that. My larger concern in the legal system is the lack of legal infrastructure.
Legal infrastructure.
Yes. That's my larger concern. Because, yes, irrespective, see, laws can be good, it can be sometimes not so good or counterproductive. The courts are there to interpret the law. The courts are not there to make the law. Law is being made in the parliament by the lawmakers. But if the strength of the judiciary is less, when I say strength, physical strength of the judiciary is less, how do you expect justice to be delivered? So that is where I would say my larger concern lies. And you have vacancy of about 30% in high courts of judges. Lower courts, you have again a vacancy of about 20% plus. Your support staff is 27% vacancy. It was in October or November 2023, there was a national judiciary report that had come out, if I'm not wrong, as on 30th November 2023. And it gave a lot of, I would say, interesting figures to show both the challenges, the good things that have happened, of course, but also the challenges and the way forward that we need to more, I would say, move towards, as I said, online courts, so on and so forth. One good thing I'll tell you what that has happened is that more than half the high courts have now started live streaming of their proceedings. So there's transparency into the system. 12 billion pages have been pages of documents have been digitized. So we are moving towards a digital setup of judicial system. Sooner or later, I'm expecting artificial intelligence will also play a role in at least ensuring that very procedural things can be taken care of. But then even today, unfortunately, there's a shortage of even courtrooms. There's a shortage of basic judicial infrastructure is all I can tell you. But at the same time, I also believe the solutions are there. Other things which are good are happening. Mediation Act has been brought in, resolving issues without getting too much into courts. About last year, about 1 lakh cases were resolved through mediation out of 4 lakh cases that were referred to. One another good step that has been happening on the legal side is this bringing in of the Real Estate Regulation Act, Regulatory Act, this is RERA as they call it. About 1 lakh plus projects were administered or were registered under this RERA authority, which means builders can't now just start a project, take money from the allottees, divert it to project B, then take some money from there, divert it to project C, which used to happen in the past. All of that is being slowly regulated with new laws that are coming. At a personal level, I'm a believer of both dharma, and I believe that long back, 2000 years back, Kautilya, the mentor of Chandragupta Maurya, he wrote his Arthashastra where he touches upon this whole concept of dharmic capitalism. Now, the long and short of that is an economy can be built strong, an economy can be built well, governance, taxations, with zero or minimal corruption, but with strong ethics. It has to be a multi-pronged approach. At a practical level, make corruption a mega crime in this country so that the giver and the taker both think, no boss, I don't want to do this. But the last 4-5 years, there's been a lot of importance given to the Indian ethos. Unfortunately, spirituality is termed as religion, which is not the case. Spirituality, I would say dharma, ethics is a little different kind of a thing. At least I see it different from religion. But if we can instill a sense of ethical business, ethical way of doing things in academics, in education, in business, in banking, in all the relevant sectors, we start instilling it now. Trust me and take my word on this. The next generation that you will see, which is 15 to 20 years down the line, they would deter corruption. They would not accept that, tolerate that.